I request Advocate Pramod Bhokre sir to begin with the session. The session is streaming on YouTube live as well. Over to you, sir.
Good evening, one and all. I welcome you all for today's digital guest lecture by Honorable Colin Gonsalves, sir. Sir is going to introduce by our coordinator, Nunal Bua, Advocate Supreme Court of India. Myself, Advocate Pramod Bhokre, ex-president of Sangli Bar Association, here to introduce Advocate Vasantrao Patil Lawyers Training Center, which has been established by our Sangli Bar Association with great support of our senior and junior members. It has been established at the auspicious hands of Honorable Justice M. Khanwilkar sir, Judge Supreme Court of India, Honorable Chief Justice our Oak sir, Karnataka High Court, Honorable Justice Ranjit More sir, Honorable Justice Sandeep Shinde sir, Judge Bombay High Court. This unique center has been established in the name of Advocate Vasantrao Patil, who was a renowned criminal practitioner in our bar. He was also president of our bar association. He had taken initiative in our bar in his tenure to arrange conferences by involving foreign lawyers, and also conducted many fruitful activities for uh, for betterment of the legal fraternity. And he added shine to our bar's reputation. His next generation is also in legal profession. Our senior member, Advocate Jaising Patil, renowned criminal practitioner. This his grandsons, Advocate Vasant, Advocate Sudat Patil, Advocate Kedar Patil, and his granddaughter-in-law, Advocate Priyanka Patil, practicing in Bombay High Court, who have generously supported to establish this unique center. Our bar vigorously take initiative for such activities, and our bar member always supports unconditionally. This platform established with purpose to boost the confidence in budding as well as practicing lawyer, to impart knowledge, to inculcate discipline and overall development of personality of advocates. And this is our motto. I am sure that with support of you all, our bar association will definitely achieve our aim for betterment of legal fraternity. And this is a pride moment for me, being a founder, and in my tenure, this has been established. Thank you so much. Now it's over to Advocate Munal Bua Mad.
Good evening, everyone. This is Mrinal Bua, Advocate, Supreme Court of India. With an immense pleasure, I am introducing today's esteemed speaker, Dr. Colin Gonsalves, Senior Advocate, Supreme Court of India. Since I had worked with him on some cases at Supreme Court, this is quite an opportunity for me to describe his journey from a Mumbai IIT graduate to designated senior advocate practicing at Supreme Court of India. He is the first Indian lawyer awardee to receive Alternative Nobel, that is Right Livelihood Award 2017, a founder of Human Rights Law Network, a co-convener of Indian People's Tribunal, and he was a member of the expert group appointed to draft the optional protocol to the International Covenant on Economic, Social and Cultural Rights 2006. Many of important PILs argued by him have become precedents of Supreme Court of India, such as Bachpan Bachao Andolan's child labor case, Kedarnath Yadav's Singur land acquisition for Tata's nano car case, Parivartan Kendra's right of acid attack victims case, extrajudicial executions victim families associations case of FIRs against killings of civilians by army, Shabnam Hashim's case of right of adoption to all the religions in India, National Association of Deaf's case for deaf people's right to take driving tests, PUCL's right to food and shelter case, and Lakshmi Mandal's reproductive rights of women case and pending case of deportation of Rohingyas Muslims. He has made a huge contribution in developing the Supreme Court's jurisprudence on death penalty cases by arguing famous cases such as Dal Singh Devangan's case, wherein the appellant was acquitted of death penalty, Mahesh Dhanji Shinde's case, and Shatrugna Chauhan's case, wherein the death penalty of 15 death row inmates commuted to life imprisonment. The execution of Rajiv Gandhi assassin case and case of execution of 4 associates of Veerappan, etc., wherein execution of capital punishment was stayed. He has contributed in drafting of Law Commission report of 2015 on the death penalty. He has co-authored a book titled as Can Society Escape the Noose? Death penalty in cases, material and death penalty cases in India, material and opinion, covering the issues of constitutionality of death penalty, juvenile offenders and rarest of the rare doctrine, etc. Now, everyone must be very eager to listen today's esteemed speaker. So I welcome Dr. Colin Gonsalves, Senior Advocate, Supreme Court of India, on board. Over to you, sir.
Thank you, Mrinal. Nice to see you on the screen, and thank you, all of you, for inviting me here today. It's quite an honor to be able to speak to you and to link up once again with the Sangli Bar. I practice in the Labor and Industrial Courts, Thane. That is after I did my IIT bachelor's degree from IIT Bombay. I practiced in the Thane court as a trial lawyer for a long period of time. And then I shifted my practice to the Bombay High Court and practiced there for more than 10, 12 years. And then I came to the Supreme Court in the year 2000. So I abandoned my home state, Maharashtra, in the year 2000 and came to Delhi, where I've been practicing here for almost 2 decades. So I'm happy to be connected again with my friends from Maharashtra. Death penalty cases are too many to be discussed in 45 minutes or 1 hour, but I'll try and give you some of the interesting features of death penalty case law and some of the recent developments in death penalty case law. And I will try maybe to enable you to see how it is possible to win death penalty cases if you know the latest case law. And if you try certain strategies and tactics and you take a certain approach to death penalty cases, it is quite possible that you can win. But you must lay the basis and foundation for that in the trial court itself. Now, you would think, as a practitioner of law or even as a criminal lawyer, you would think that if a man has killed his entire family, including children, and that is established in a court of law, you would think that the chances of death penalty are very slim. And it is quite possible that you would, in your mind at least, think, you may not tell your client, that this man is going to the gallows. So particularly in cases of grievous crimes and heinous crimes, young lawyers would generally feel that their chances of their client are very slim. If conviction has been sustained, say the trial court conviction has been sustained by the High Court, you would think now nothing really can be done. Because on the evidence, it is clear that this man has committed the crime. So I'm dealing with those category of cases where the evidence is very clear. The evidence is overwhelmingly against the accused. And there is really no hope on evidence to try and get an acquittal. That is to say, the conviction is a foregone conclusion. The crime is very heinous. How do you, as a young lawyer, when you look at the papers for the first time and you see that the crime is heinous, and then you go through the trial and you, my God, this is really stacked against me. There is nothing that I can do. And the trial court has convicted. And then you go to the High Court and the High Court convicts. And you're standing in the High Court and you think nothing can be done. In such terrible cases, what can a lawyer do? You may not get acquittal, but how can you escape the gallows? Because very often trial courts and even high courts routinely make the mistake that if the crime is heinous, the man must die. And you'll hear so many judges, even in the Supreme Court, say, this is a heinous crime, Mr. Gonsalves. We are not interested in listening to any of your arguments. We are only looking at the crime and your death sentence is confirmed. You can take it from me that your death sentence. So in today's talk, I am focusing on that aspect. And the first mistake made, even by judges of the Supreme Court often, is that while deciding death sentence cases, they look at the crime and not the criminal. And you'll find so many judgments, judgment after judgment, looking at the crime, setting out the facts relating to the crime, and then jumping to the conclusion that death sentence must follow because the crime is heinous. Sometimes they may look at mitigating circumstances, this, that, and the other. But if you look at the analysis of that, you will find that there is hardly a reference to the nature of the accused. And when I say that, what do I mean is the accused capable of being reformed? He has committed a heinous crime. He has killed multiple persons. He has killed children. He has raped and killed children. In court, his demeanor was very casual, as judges will sometimes say in the judgments. He was smiling to himself. He showed no remorse. It is quite clear. I watched him. He showed no remorse. It seems this man is incapable of reform, and therefore the death sentence. Now there has been in our Supreme Court an explosion of case law. I would say roughly 10 years, the last 10 years. And it's important for you to put your fingers on that. And I'll give you a very good source from which you will get all the help that you need, so that the information will not be with me alone. The information will spread to everybody, and you can get the best case law in the country. So it's not the case law so much that is important, though I'll give you some of the case law. But I'll give you the source of that case law so you can collect all that and prepare for your death sentence cases. And a death sentence case is very easy to get, to understand, because it will be the heinous of the crime which will determine whether the judge gives you death or life in prison. So the first thing is you must look at the nature of the criminal. Now let us go back in time to the leading judgment on death sentence, which is Bachchan Singh's case. But in Bachchan Singh's case, although it is so well known, the main paragraph is so little noticed. As happens with many historic judgments, we think we know it, so our eyes don't catch what is very important to notice. And in Bachchan Singh's case, and the citation of Bachchan Singh, you know, but I'll just give it to you anyway. 1980, 2 SCC, 684. And it's the usual mitigating circumstances and all that sort of stuff. But the jewel in the judgment, if you like, is paragraph 206, where the Supreme Court talks of mitigating circumstances. And the jewel inside the jewel, if you like, is paragraph 206, subparagraph 4, which says, the state shall by evidence prove that the accused does not satisfy the conditions of 3 and 4 above. And 3 and 4 are, 3 is the probability that the accused would not commit the criminal acts of violence as would constitute a continuing threat to society. Namely, man has done terrible, terrible crime. But is there evidence to show that notwithstanding him having committed that crime, he is not likely to be a continuing threat to society? And 4 is, subsection 4 is, the probability that the accused can be reformed and rehabilitated. Okay? Can be reformed, can be rehabilitated, will not constitute a continuing threat to society. This is really the jewel in the judgment, on the basis of which there might be maybe 50 case laws of the Supreme Court dealing with this aspect. Therefore, Bachchan Singh says, and you all know this, it must be the rarest of the rare case. So one parameter of rarest of the rare is that heinous crime, very heinous. But that's only the first step. The other steps are, and the wording is like this, the state must prove he is not capable of being reformed, not capable of being rehabilitated, and that state must prove that he would remain a continuing threat to society. When he's in jail, again, he will commit murder. If he goes through life imprisonment and comes out when he's released after 14, 20 years, he will again commit the murder. State must prove. Now, what happens in all criminal trials? State doesn't bother to prove anything. Universally, if you look at all the Supreme Court judgments, the Supreme Court judgments that gave death sentences, they also didn't read Bachchan Singh properly. Or in some cases, they were not interested in reading Bachchan Singh because they were so convinced that the man has to be killed. Bloodthirsty. What can he argue? He's killed so many people, we will get rid of him. He's a menace to society. Bloodthirsty. All the judgments, if you look at all the judgments of the Supreme Court where they have sent a man to death, state proved nothing in all these cases. State proved nothing in all these cases. State did not bother to lead evidence that this is the nature of the person. He can't be reformed. Can't be rehabilitated. And I, of course, have been a die-hard person against the death penalty. And I always give this example of Angulimal and his relationship with Buddha. And how Buddha felt that he can be reformed. Anyone can be reformed. Many don't agree. Anyone can be reformed. And ultimately, he turned out to be a great devotee and a bhakt. So from a terrible murderer who found the fingers of his victims around his neck, he turned out to be quite an extraordinary person. Now, what does it mean that the state must prove? You must lead evidence. And as I said, in many cases, there is no evidence. So if you argue in the Supreme Court or the High Court, sir, just look at the record, look at the judgment. There is no evidence at all. State has not bothered to read any evidence. How have the courts looked at this? And I'll give you some of the judgments in that regard. I'll give you a few citations and I'll give you the rest, perhaps indicate where you can get it. Rajesh Kumar, 2011, 13 SCC 706. 2011, 13 SCC 706. The state has not given any evidence to show that the accused is incapable of being rehabilitated, or that the accused is a continuing threat to society. Many judgments now. But such a simple thing, when you go to the High Court, or if you come to the Supreme Court, just look at the judgment. Grievous crime, grievous crime, grievous crime, grievous crime, grievous crime. Therefore, I find he deserves that sentence. So for a lawyer, it's such a simple task. Just read the judgment. Or there'll be some observation. He showed no remorse. He smiled to himself. He did not cry in court. Therefore, now what does the Supreme Court say? The Supreme Court says now this is no good. This is no good. And on sentencing, you must not do the sentencing on the same day as the conviction. I'll give you some of those judgments. Give the accused a chance to go back. Give him maybe 3-4 days, whatever. He will go back to his cell. He must be told by his lawyer that, listen, now you can request the court that I want to lead evidence that I am capable of being reformed. I am not that kind of monster, although I've committed a terrible crime, that I should be put to death. So the conviction has come. But I get a chance still to request the court to lead evidence on the aspect of my nature. Very few lawyers take that. When the conviction comes, first of all, very often on the same day, and that is condemned. Can't do that on the same day. So that the man goes back and takes a chance to lead evidence. What kind of evidence? His parents can speak of the life that he led, the difficult life, whatever happened, what caused this killing that he did, this terrible crime. His school teachers, his college teachers can come and give evidence about the man. And particularly in the case of first-time offenders, and very often many death sentence cases are first-time criminals, clear record. What was it that, set off that spark which caused the man to go and commit such a terrible crime? The first crime, only crime, terrible crime, death sentence. His friends, his well-wishers, respected people from his village who will say this was the man. He came back every year to our village. He promoted things in our village. He did good things. He was a respected member of our society. And the most important evidence, the evidence in prison. So he's arrested. It would take 10 years maybe to reach the Supreme Court, trial court, high court, Supreme Court, mercy petitions, etc. 10 years, 12 years. What was his performance in jail during that period? Meticulous record in many cases. I would say 90% cases, the person in prison has a clear record. So Supreme Court said in Birju's case, 2014, 3 SCC 421. 2014, 3 SCC 421. And there are many judgments. I'll give you one only. The accused can call for the probation officer's report. The accused can call for the prison superintendent's reports over all these years of good behavior, normal behavior, non-aggressive behavior, compliance with the rules, the prison rules, to show that you are not incapable of being reformed. So the probation officer's report and summoning of the probation officers is a very important step to take by a defense lawyer after the conviction order has been delivered. Many judges will say, how can you now lead evidence? Your evidence is closed, isn't it? Chances of you leading evidence, you didn't take it when you had the chance. But evidence on the crime is totally different from your decision that the judge is going to make on whether you should be sent to death. That has nothing to do with the crime now. Once you have convicted me, whether or not I'm going to be sent to death has nothing to do with the crime. Because death sentence is in all heinous cases, right? So heinous case is the substratum. You take it for granted. If you're going to be sentenced to death, it must be a heinous crime. So you have to exclude that. And now look at the criminal. The conviction looks at the crime. The death sentence looks at the criminal. And in the case, when you lead evidence about the crime. All the prosecution will prove the crime. So when the judge says you can't lead evidence, I'm sorry, your stage is over, you take him now to the case law relating to the evidence relating to the criminal. And if the state doesn't lead evidence, then finish. They can't sustain the case, death sentence. But you can go further and you can lead evidence. Like I said, your teachers, your professors, your friends and associates who have some position in society, who speak highly of you. I remember so many cases where we led evidence of the teachers. Relatives who have high position in their panchayats and in society, and got away. So the Supreme Court says, even if the accused doesn't do it, even if at the time of the trial court the lawyer doesn't do it, even in the High Court if he doesn't do it, at the Supreme Court you can make an application. That, sir, I forgot to lead evidence. My lawyer forgot to lead evidence on me. Please allow that evidence to be led. And the Supreme Court can take in evidence at that level. Or the Supreme Court can ask the High Court to lead evidence and take that into consideration in deciding this. Lack of criminal, now I'm coming to the second point, lack of criminal antecedents is a very strong point in determining that death sentence should not be given, even in the case of heinous crimes. I'll give you one citation. Gudda versus State of Madhya Pradesh, 2013, 16 SCC 596. Young age. Person is young, 35, 40, 45. Very good argument in favor of not giving the death penalty. Poor. Now that's a new ground. Earlier, judges would say, Never mind if he's poor. What difference does it make? Committed a heinous crime. He should have known. But now poor economic conditions is also a good ground to argue that a person should not be given death sentence. Sunil Gaikwad versus State of Maharashtra, 2014, 1 SCC 129. And I remember one case I argued for Maharashtra. I forget that citation now. I'll get it later. Where a particular Baba took people up the mountain somewhere in Maharashtra and then promised that, he would shower them with some wealth and so on, and kill them and rob them of all their. And I remember that case where the accused were young people. I hope it's the same. The accused were young people. And in prison, they had written a book on Gandhiji. And the other young people had passed their BA, I think MA and so on. And I didn't think that, all right, he's studying in jail. Everybody wants to study. And then some poems on Gandhiji and so on. I didn't think. The evidence was overwhelming against them. And I thought I had no chance. I finished arguments after many hours. And judge was totally against me. And then from my side, counsel said, try and show them this. So I showed them, so he's been writing a book. If you're writing a book and researching and you're seriously writing and you're studying, does it not show that you are capable of being reformed? You can live a totally different kind of life. And suddenly something clicked in the judge's mind. He said, show me. I showed him the book. Showed him that he had passed his BA and so on. So then there was some chatter among the judges. They didn't indicate their mind at all. They looked as stern as before. And then when the judgment came, it came. No death sentence, life. So youth and demonstrable ability to change. Something, you must have some evidence to show that the person is trying to change and becoming a person for the better. And poor economic conditions, I mentioned that earlier. Many cases, I mentioned to you, many cases of a family being killed, which is a very difficult case to take out of death sentence. And yet the courts have said no death sentence because they looked at all these factors. They looked not just at the crime, they looked at the criminal. And I'll just give you one. I've got a series of about 20 judgments on gruesome crimes. I'll try and give you one. Amar Singh versus State of UP, 2014, 13 SCC 443. Where he killed 3 persons, wife and 2 children, commuted to life. Now let's leave this aside for the time being. Let's go to something, because time is short, so I want to focus on some things and give you some. Swami Shraddhananda's case is a very important case. Until today, I think even the Supreme Court has not understood the impact of this case on death penalty jurisprudence. Swami Shraddhananda is 2008, 13 SCC 767. In our code, we have 2 extremes. You have life imprisonment and you have death sentence. and life imprisonment is subject to remissions and so on. So people say in heinous crime cases, what was the point? He killed our family, and what did you give him? Earlier, 14 years. Now, of course, life means life, but with remissions, you come out. So it's possible you'll come out. And this man is so dangerous that, we don't feel safe if he's inside, if he's outside. So in Swami Shraddhananda's case, the Supreme Court said, there's a third alternative, judge-made law, which we will give you, which is life means life, and life in prison means in jail till you die. That you know. Now think about this. Once you have life until you die, you cannot come out and be a menace to society. That big consideration is gone. Yes. And if he cannot come out and be a menace to society, and if he stays there, say at the age of, let's say at the age of 50, 40, he's put inside and spends 20 years in jail, is that not a punishment as grievous as death sentence? Probably if you ask many criminals or accused persons, when faced with the question, do you want to be hanged or do you want to be in this jail for 25 years till you die? They may say, sir, you put me to death. Because it is a punishment worse than death. Often. It's a punishment worse than death. So that revenge in society, that I want to take revenge against this person, and all you human rights activists, you are all soft on the criminal. Now they can't say that against us, because the man is going to stay like an animal in a cage for 25 years. What can be worse than that? Every morning get up, every night go to sleep. Chained to your cell. So that revenge aspect goes. So Swami Shraddhanand raised the level of the death sentence imposition to a very high level. Now you must show, because threat to society is no longer, Bachchan Singh's criteria is no longer applicable. Doesn't matter if his threat to society is incapable of being reformed. And therefore, the only consideration now is, how did he perform in jail? So when you focus on that, as a defense lawyer, when you focus on that and produce the record that his conduct in jail was good, the man cannot be put to death. Cannot. Now there is controversy in the courts. Can you look at that? Can you look at his conduct in court? Everybody in like one judge told me, everybody, once they realize that they are going to die, they become good. To which my answer is precisely. If my conduct is good and I realize what I've done, that is precisely the reason why you don't put me to death. Because according to Bachchan Singh, I am not incapable of being reformed. Exactly. And as I said, everybody's conduct is pretty good. Everybody's conduct is pretty good. There's no reason to put people to death anymore. Once you take out that feeling of revenge, eye for an eye, by saying, okay, we'll keep him there forever. There is no reason to have death penalty in India. And as lawyers working in the criminal court, I want to tell you, please develop this conceptually. Death penalty cases can't be handled only on, this evidence, that evidence, this cross-examination. It must be handled conceptually. Why would you put a man to death? If 99% of all people in jail perform their services properly, perform their duties properly. So Swami Shraddhananda is actually a historic part of our jurisprudence, which basically calls for, not explicitly, but implicitly, the abolition of the death sentence. Now I want to shift to something else. because I think time is very short and we are already past my 30-minute mark. So I will take up one last topic and then we'll keep it open for discussion. The mercy petitions. And I want to talk about Shatrughan Chauhan's case. Shatrughan Chauhan's case is 2014, 3SCC1. My favorite case. My most favorite case. Shatrughan Chauhan was a lead petition in the case, in a series of cases, maybe 8 or 9 cases, involving about 16 accused. Their cases were pending in court. They were convicted. Conviction was confirmed. They made mercy petitions. Mercy petitions dismissed. No hope. 6 o'clock in the evening at Delhi, we received a phone call from a journalist who said that he's connected with some of these death sentence accused persons. And they've got information from jail that the hanging is being prepared. Everything is made ready, the machinery is being cleaned, and the prisoners are asked if they want to have, good food, and they're given clean clothes. This was 6 o'clock in the evening. My dear friends from Bombay who know a lot more about death penalty than I do, Yug Chowdhury, many others, but very fine understanding, drafted the petition immediately. So maybe it took him an hour, 2 hours to draft the petition. It came to Delhi. So by then it was already maybe 6, 7 o'clock in the evening. We approached the registrar, telling him that 16 persons on death row whose conviction had been confirmed and the mercy petitions were dismissed were scheduled for hanging at 5 o'clock the next day. And what was the ground in the petition? The ground in the petition was that the mercy petitions had been pending for 8 years, 10 years before they were dismissed. Delay in disposal of a mercy petition by the President of India renders the sentence of death unconstitutional. An order directing your hanging, lawful when it was made, is rendered unconstitutional by passage of time. Because keeping a person under death row for 10 years is akin to torture. And therefore, it renders the decision to hang, the order to hang, unconstitutional and should be set aside. Cruel and inhuman behavior on the part of the state to keep a person under the shadow of death for 10 years, 8 years, 12 years. Now, which were these cases? The most controversial of all cases. The Rajiv Gandhi assassination case, the Veerapan killing case, the Veerapan gang case, where they killed many people, blew up police vehicles, killed so many people, the Veerapan gang case, the Bullar case in Punjab, and so on and so forth. See, death penalty cases are a very magical kind of case. You have some judges who are very cruel. Some very fine judges, I've heard them once. At Berkeley, there was a university He had gone for a lecture there. And a very fine judge of our Supreme Court said, during my tenure as a judge, I have passed death sentences in 12 cases. And I have not slept badly because of that. Proud. So proud. So proud. I was so shocked because he was a good judge and I knew him also. Well, knew him well. Kind judge. But death sentence, it made him a little imbalanced. So, these were all controversial. The Buller case was Punjab. It is said that he put a bomb and killed a policeman. Rajiv Gandhi, all this killing of Rajiv Gandhi after he had left office as Prime Minister and so on. So here we are standing outside the Supreme Court. I'll finish now in 5 minutes. I realize you must be tired. We were standing outside the Supreme. It was rainy season. And we had carried all our books and a lot of reference material and so on. Standing outside the Chief Justice's residence, Chief Justice Satashivam. People have different views on Satashivam, Chief Justice Satashivam, but I really like that judge. Not only because he gave me this order, generally I liked very much. So waiting and waiting, 7 comes, 8 o'clock comes, 9 o'clock comes, 10 o'clock comes, and it's raining and we are getting wet and still he's not called us in, which is a very bad sign. And at about 11:30 at night, the message comes, you please come in. So we all troop in. And we are taken to the chamber of Justice Satashivam. We enter. Worried. He comes out from behind his table with a broad smile. And I think, oh, not bad. We're starting with a smile from the part of the judge. And then he says, Colin, why are you bringing all these books? Second good sign. Why are you bringing all these books? Because that's at this case, I brought books. We thought we need to argue. Very good sign. And he sits down and he asks, how long did the president take to decide? I said, average 8 years, running from 7 years to 12 years, 13 years, 14 years, 15 years. So your argument is this, that delay renders the death sentence incapable of being operated now. I said, yes, sir, that's how short. All right, all of you sit down. And then he said, issue notice, stay. And he was so kind, and I can never forget this day. He said, I'm waiting here. He told his court master, call up all the jails. And I will leave this my chamber when you confirm to me that all the jail superintendents have been personally informed that I have granted stay. Because there's a real chance. Somebody may miss, somebody may not get the message, and the man's life is gone. We sat there. Then he gave us tea at night, did a little talk with us. It took about half an hour for all the jail superintendents to be contacted. And then we went. And months later, he heard the matter finally. He heard all the case law. And he laid down the law for the country. Delay by the president, which is not explained, unconscionable delay, will render the death sentence invalid. And it is such a historic judgment today that I saw the Supreme Court of Uganda, Tanzania, and so on, using these judgments in their courts to set aside death sentences. And so, my dear friends, I gave you just a little flavor of death sentence litigation, but it is very exciting litigation. And judges are not educated on death sentence litigation. So you must play a very important role of having all the case law at the tips of your fingers. And I will tell you now the best source, National Law University, Delhi, have a death penalty project. And they are the champions in this field. And they have educated lawyers throughout the country. They have taken us, including myself, from lawyers who had just a few case law and some impressionistic view. They have trained them to be good quality death sentence lawyers. Now you please contact them. You can do it on email. You can go, and the name of the leader of these death sentence, anti-death sentence warriors is Dr. Anup Surendranath. Harrison, no end. He's very helpful, but he might get sometimes very irritable by what I've told you today. People from all across the country are, telling him. And ask him to give you the summary of the case laws. Main point, which are the case laws? And then you study the case laws yourself and use them in courts. But death penalty litigation in this country is very sophisticated because of this group. And take up death penalty litigation fearlessly, even in cases of grievous crimes, where nobody else will touch it. Nobody else will touch for two reasons. One is that it's a grievous crime. And the second reason is all poor people. So I do hope from those of you who are participating today that you never reject a case because the person has no money. I have seen death penalty litigation takes time. And I've seen lawyers go for death penalty cases without reading their papers. I've seen a senior lawyer in a juvenile case where there was a certificate of juvenility on record, didn't bring it to the notice of the Supreme Court. And I said, sir, why did this happen? Why did you? He said, nobody briefed me. Nobody briefed me. So I'm expecting a junior lawyer to read. Junior lawyer didn't read. So I didn't tell the court he's a juvenile, sir, as on the date of offense. So he could not be given the death sentence. Can you imagine? And then I went before the court, Supreme Court, and they said it's over now. Review is done. Everything is done. You can't do anything now. And after telling me you can't do anything, the judge did exactly what I'd requested him to do. He said, we will find a way. And they mentioned that we made a mistake. We should have noticed that the juvenility certificate is on record. Still, we dismissed the thing. So I leave the petitioner to do whatever he wants to do, but we had made a clear-cut mistake. And even though the review petition is dismissed, you can't have second review, but we are admitting that we made a clear-cut mistake. And then ultimately, the judges of the Supreme Court found a way. They have their own ingenious ways of doing things when their conscience is troubled. So they did a fantastic thing. And they reopened Om Prakash's case, a boy from Bihar. Reopened the case. Juvenile court confirmed, yes, he was a juvenile. Sentence of death set aside. Sentence reduced to period undergone. For a juvenile is 3 years. The moment he was released, he ran away to Bihar and got married. And he's probably living a nice life now. Why? Because the lawyer took pains to read the papers and point out to the court. Against all odds. That, sir, you made a mistake. Please look at it. And with that, my dear friends, on that optimistic note, I will end this talk today. And I thank you for listening to me very patiently. And I do hope I satisfied your thirst for information on death sentence. Thank you very much.
So participants are there and they are very much eager to hear you. If you are willing to continue, you please do so.
Yes, I can do it for some time, not very long. But
Yes.
if you have questions, we can answer them. Yes.
Okay, sir. So I request Dr. Sheetal Babar ma'am to take up the question answer session. Over to you, ma'am, please.
Yes, sir. Good evening, sir. So, after this wonderful, stupendous session, there's certain brightest viewers of ours who do have some queries regarding this topic, wonderful topic of death penalty, and then listening to you is definitely a privilege. The few questions popped up by our viewers concerned to the recent topics. We're trying to ask in all of these questions. I take this opportunity from all of these viewers to ask you a few questions. The first one of which is, as you talked about the capability or incapability of reformation. Rather, you were talking about incapability of reformation for a while. There is a question regarding to this, that who all decides this capability or incapability of reformation of an accused and on what grounds, and if it is based absolutely on the judges and their discretion, then wouldn't it be a bias concerned to actually imposing of the death penalty?
No, that's criteria. Is the person capable of being reformed or not? I indicated in my talk itself, one of the ways to do it, and I'll restrict myself to this one example, is to ask for the prison record. So the prison superintendent will produce the social worker's record, and they'll give an opinion. That'll be one criteria. So they will explain that, sir, for the last 10 years that he's been in jail, we have gone through the records, and the records show that he has done very well. He has reformed himself. He has not got into fights. He has not attempted to kill somebody else, etc., etc., etc. So it's very objective. And it's a prison record. It's not your personal record. It's a prison record.
Thank you so much, sir. We do have one more query concerned to, is there any specific criteria where courts affirm that particular offender can be reformed? Averagely, if there is any principle which is followed on which majority of the cases are taken into consideration, as to these are the principles onto which we say an individual is reformed, or are these only which we just talked about the officials reports and these?
No, there are other principles as well. For example, if he's a first-time offender, right? There are so many reasons why if he's the first-time offender and he's led evidence of people from society who knew him, right? And they know him and they speak of the person and they speak of, and they probably say the reason why this happened was because, in a fit of anger this happened, or because there was a relationship between his wife and somebody else. They try and give explanations as to why the person who committed a heinous crime departed instantaneously from his past years of being a good citizen in society. They try and give the judge some explanation. Apart from now his conduct in jail, his evidence, he can lead evidence, his people can lead evidence to show that normally he was quite a normal person. And certain things happened in his life that made him imbalanced. And it's quite possible that after he gets over this imbalance, he would be a normal person. So these are objective pieces of evidence, let's.
So say, for example, as in you were talking about a teacher's opinion about an individual, how he or she was in the school, can also be one of the references to consider whether he is born criminal or there are certain circumstances which dragged him to these situations. So these can be exempted.
Yeah, well, nobody really is born criminal, but the teacher will give you an insight into the boy's background. Whether he had a troubled life, whether he had a very poor life, whether, when he was young, he was abused. So many criminals, so many young accused persons, if you even, look at their history, you'll find often when they're on the streets, they will be sexually abused on the streets. They've been beaten by policemen. They've been sexually abused by policemen. They grew up very hard. And their view of the world was very, tortured. So these explanations are given to the judges.
Correct. So probably the circumstances in which he's been dragged to commit certain acts, rather not to call him a criminal. So yes, we proceed with one more question. So looking at when you just talking about, let us not take an individual as a criminal while punishing, but let him consider as an individual, and let us not consider the crime. So in this, when it comes to IPC, or when it comes to all the penalizing laws, they are absolutely non-discriminating. They don't discriminate on criminal's age, on the gender, on his education. But then as per you, it totally depends on the circumstances of that individual. So we need to consider him not as a criminal, but then doesn't law specifies different criterias, and what you just stated, with all the due respect, is onto a separate footing.
Of course, there is grounds on which you would positively discriminate. Let us say, if you're young, why should he be put to jail, put to death? You know what I mean? If you're poor and you've suffered in life, you take a softer view. If you're a woman, you take a softer view. Why should you put a woman to death generally? You know what I mean? So generally, I think you must find, the role of the lawyer is to find good excuses
True.
to avoid death sentences.
True that.
And the role of the judge is to look for lawyers who are giving them very good excuses. I know what the case law is. I know that the crime is heinous, but this lawyer has given me a very good excuse. Like I told the judge, remember, this man has written a book on Gandhi. This person is studying for his master's degree. Give them good excuses. Why should you put people to death? We must get out of this killer instinct,
In fact,
yeah. If you go to Europe, even terrorists, not a single person is put to death. If you ask students in Europe, go to the classroom, and you say, how many of you support the death sentence, they would think that teacher is mad. Not a single student will say they want death sentence. They would say, who is this professor? Let's throw him out. He's asking about death sentence, which we abolished 20 years ago. But you go to an Indian school, Indian college, you go to an elite college and ask, how many of you are in favor of death sentence? Half the class will put their hands up. As a society, we have become very morally degenerate. We call ourselves civilized. We think we are very civilized. But we are killers. Inside, scrape a little bit, killers, take revenge. Kill him, hang him, shoot him. We have to think first, before all this law chakkar, how to be refined people. That even in the face of provocation, we do not seek violence. We have to think of ourselves as a cultural entity, a nation of cultured people. How do we rise above this rubbish of killing? And death sentence is very important to go.
Yes,
the day the death sentence goes, I would say India has become a refined country. As long as death sentence stays, we are not refined. Do we not want to be a refined nation? How? Anyway, that's for another day. Thank you very much.
Thank you so much, sir. Thank you so much, sir. If you just allow me to ask few more questions.
Sure.
I would just sum up with few of them. Majority of the crowd is basically dying to listen to your opinion on Nirbhaya's case. They just want to know the judgment, the decision.
I'll respond straight away. It is quite possible, I don't know the evidence, so that's why I'm using this language. It is quite possible that the judgment on conviction is correct. It is quite possible that these young people committed a heinous offense, and it is quite possible that they were correctly convicted of that crime. I don't believe that they should be hanged at all. I believe the Swami Shraddhananda judgment, where they'll be kept in jail for the rest of their lives till they die, would have been an adequate alternative to the death sentence. And you remember what Bachchan Singh says, that it is only when the alternative is not completely foreclosed. You understand? I believe in Nirbhaya. Once Swami Shraddhananda comes in and judges are allowed to give life imprisonment up to death, they would have rested in, they would have been in jail for the rest of their life. The judgment on death sentence is wrong. After Swami Shraddhananda, these judges had no business giving death sentence. But nowadays, judges are very tuned, listening to public opinion. Oh, there'll be an uprising against me if I say you will remain in jail till you die. You never know. You never know. If an enlightened judge gives an enlightened judgment and he explains how these young people who are in their 20s and 30s spend 40 years in jail, 40 years in a cell, and it is as harsh as the... All right. Her mother may not agree. She will campaign for death. I have known, let me tell you, many children and wives, victim families, the wives and children. I have interviewed some of them. I said, now, why are you asking for death? They said, because, sir, this is earlier, sir, they will come out after 14 years. Is that just, they've killed our family members, they'll come out after 14 years, they'll be free. I said, madam, suppose you were told that they will not come out after 14, they will not come out at all. There's this new judgment. Death means life means life. They can't come out. Then what would you say? हमें बताया कि लाइफ इम्प्रिजनमेंट नहीं है, वो 14 साल के है. अगर हमेशा के लिए रहेगा तो हमारा कोई ऐसा ऑब्जेक्शन नहीं है, रहने दो. उसका मौतें जो है शुड नॉट बी ऑन माय हैंड, चलो रहने, कोई बात नहीं. हमारा डर तो दूर चला जाएगा. हमारा डर नहीं रहेगा कि वो बाहर आके मुझे दोबारा हमारा फैमिली को परेशान करेगा. हमारा डर नहीं रहेगा. नो प्रॉब्लम सर. Many people are not in favor of death sentence from victim side.
True.
But the propaganda for death is very high in our country. Right. Everybody will beat the drum. Maro sale ko, maro sale ko. And if anybody says, no, no, sir, kindly think, you do Swami Shraddhanand judgment to criticize karega. They will attack you. They will attack me. You understand?
True, true, sir.
In Nirbhaya's case, I believe, convict the persons, put them in jail, keep them there for the rest of their lives.
Right. There is
They
always
made a big mistake.
There is always another side of the coin.
No, of course. Mine is only one side. No. The other side says, oh, you just hang them.
So there are two sides of one coin, basically. We need
always.
Yes,
always.
on this very footing, there is one question from one of the spectators and the listeners. He wants to ask this question: when the Law Commission has suggested the abolishing of capital punishment, and when capital punishment has failed the test of deterrence, where is the dilemma from human rights point of view?
See, once the law commission says don't do death sentence, once the law commission says don't do death sentence, what's wrong? Why should they keep the law contrary to the law commission recommendation?
Right. There has to be.
So politicians, you see, let me tell you, politicians never want to do anything in society. In the Nirbhaya case, what they should do is, and in all other cases, you have to reform the police, you have to educate society. Karna nahi.
Right.
Anything happens, they want to appear to be very progressive, very courageous. First thing they will say, death sentence hona chahiye. It is simple. Politician doesn't want to change society, you know. They just want to win elections and get away.
True, sir. Very true. So I shall just be concluding with the last question. Probably I have much personal interest into this. The question is, though in rarest of rare cases, there is imposition of capital punishment. However, it takes a lot of time and procedure for actual execution of this sentence. So isn't basically, now this is another side of the coin properly, probably which you were actually discussing. So isn't this the violation of human right of the convict for that long time when he knows that he's going to die or he probably is going to be hanged? So isn't that time span actually the violation of human rights of the convict?
See, that has been argued in many courts, that the criminal justice system takes too long, so that itself is a violation of the human rights of the prisoner, and he should be released. He should not be given death sentence for that.
Right, sir.
But the courts have generally not accepted that argument.
Right, sir.
Unless there was an extraordinary delay in the trial, then it would vitiate the sentence of conviction also.
Yes, sir. So just a last question, as we were just going through your biodata and we could not control ourselves asking about this ICSCR protocol. Why India hasn't signed yet the protocol of International Covenant on Social, Economic and Cultural Rights? Is there any specific reason as to we are not the signatories for especially such kind of international documents which absolutely abolishes the death penalty or capital punishment as one of the punishments?
See, India will not sign any document, without going into specifics. India will not sign any international document which says death penalty should be abolished, because they don't have that stand. There is no reason for them not to have that stand.
Right.
India has no fear.
True.
Now you are in jail for the rest of your life, so why should you bother? Why should you not culturally improve your standing in the international community? International community every 4 or 5 years will condemn India for death sentence. Condemn India. They say the civilized world has abolished. Only some barbaric, backward, let's say, societies, whom we call barbaric anyway. Some barbaric societies have it. So why is India among them? Everybody asks us, and we have no answer. So why are we among the barbaric practices and not with the enlightened societies of the world? We have no answer.
True. So basically, we need to increase in adapt more socially to the world, or we need to cope up with culturally with the world, I could say, when it comes to this discussion of death penalty to be or not to be, and this dilemma of human rights. So I shall take your leave. It was wonderful conversation. It is just a privilege to talk to you. I hand over the session to Sudatta sir. Thank you so much, sir. Thank you.
Thank you very much. Hope to see you in Sangli.
Definitely, sir. We would love to see you. Thank you so much, sir. Sudatta sir, if you could just take over. So we could send it to each other and people also.
Thank you, Sheetal, and extremely thankful, Colin sir. I understand. I mean, it's not easy to take one side of the coin and that too so controversial, and talk so boldly and be so expressive about it. I was seeing the chat boxes and they were very awkward questions, flowing, and you were so vocal and so expressive about the thought you have, and you're very, very pursuant about it. So I think it's not really easy. There's a lot to learn from you, sir. And I think this was a wonderful session. We loved it. Sir, I would like to tell you that this was our first webinar, and you had really enlightened us on this very, very controversial and burning topic of death sentence. I thank you so much, sir, on behalf of Sangli Bar, for coming and for this e-meeting and for this e-experience for all of us. Sir, I have to thank Sangli Bar also for providing this platform for the Lawyers Training Center. I want to thank the committee of Sangli Bar, and I want to thank the coordinators and the conveyor committee of the Lawyers Training Center. Last but not the least, sir, I want to thank all the participants who had come. All of them have been glued to the computers. They have been seeing you. A lot of familiar faces I could see on the computer. A lot of them on YouTube were watching us. Sir, I hope you keep coming. And once this threat of COVID is over, we would invite you personally to Sangli Bar, and we hope for a physical session where we can have a live interaction with you, sir.
I'll be happy to come.
Thank you so much, sir.
And thank you, Sangli Bar, and keep up all the good work that you all do. Keep fighting.
Yes,
keep
sir.
fighting.
Yes, definitely.
Never give up. Never give up.
Definitely, sir. Sir, with your permission, I would see if the session can end today.
Thank you very much.
Thank you, sir.